Abisha for Miss Ansimobi Aqua Shoko Passa Bay or Dinusi, the beer than in Samahodoa, Elcoso, Oyaman Ghana Masi, see a basha. Eya Bra His Excellency John Dramani Mahama, Everton Kunyakesi, and this presidential sitting no so no. Eya before Sir Obert Nasokano, or can send me say, so nya be president Namaya Duma 2024 on 7th of December, dear. Ebisha for or nipa bi oba obeyi omo free abemu nipa obo omudi ebi ti se IGP dampare oba ya no yi IGP dampare efiri ho e do the IGP Christian yo woni tete ebae e na osaka se so oba e Chief Justice se wa Getro Tokunu ono nso obeyi na free because ne niema bi enso ani e call fa e traveling agent so insem bebre Emma same way kwa kopim US court for even Commonwealth for Edomanu Jim about the removal of Chief Justice Getro Tokunu. So right now no case in Ebusha for Akochi Akobrema Eko US never Supreme Court never High Court. Sisia eya same way aba bedu High Court. Na Ebusha for me ye for Supreme Court e aba High Court because say Sisia no eye mama isi on to me say eye so bo petition eye His Excellency any committee na omote no e dey born say waye no enam so emosi emu kwan no even our former Chief Justice ebusefo omo nyina aba bekebi so fire kufu aba bekebi ono no ka committee no o say petition na omo dey bo Getro Tokunu Chief Justice na ebusefo emu nyedu enye heavy enough say His Excellency John Dramani Mahama ebegina so aka chere say mami we mintime no enye adwuma bi osisi a mami Getro Tokunu also on ne ho ase nam so amasisi asem no dovolo ebisofo ono so di na no aba betumi enam so amamafo kasese even say His Excellency ebetimi anam this particular petition so aka che mamini say on free ho that means papa ya mi boni dovolo ono so betimi aka che anaso ono so betimi aba be Chief Justice that should be Ghana has it but only qualities no so the baby Chief Justice come home na chesi yenkoti nsem no munchemu nsem na kwa koye bebre about this particular case name mum no meso say subscribe to thr0wn TV like a comment or comment section so click on the notification button for more news updates thr0wn go team mercy midas.
What's the strategy of the former Chief Justice in going to seek or filing an application at the High Court to challenge her removal as the judge at the Supreme Court?
Well, okay, thank you. I think, I don't know, I haven't listened into the program, so I don't know who and who are there. If you have some lawyers around, I think they do know that what happened was an administrative tribunal to which this matter was referred. Article 146 allows the or invests power in the president, having received a petition for removal and having established a prima facie case with the Council of State, who set up a committee of inquiry going into this matter to confirm that it worked. The prima facie determination that they had made. And so that committee is an administrative body. Under Article 23, they were acting not as judges, because as you know, there were only 2 judges, the rest were all laymen. So being administrative bodies and administrative officials, their actions can always be subject to judicial review, and the High Court has jurisdiction to deal with such matters. That is why the Chief Justice chose to go to the High Court and not necessarily to the Supreme Court. I hear some people talking about Supreme Court. Supreme Court is for interpretation, and interpretation comes in only when you are not sure of the words used. In other words, if the constitutional provisions are ambiguous, they are subject to more or 2 or more interpretations, then you want to go to the Supreme Court, which has the sole authority to clarify what they think that provision means. Otherwise, as was stated many years ago in the country, so long as the law the constitution is also a law of this land. It can be applied as when they are appropriate. You don't need every time to go to Supreme Court. Again, in the event that the High Court judge finds that the what is being called upon to deal with amounts to an interpretation, he has the right to refer the matter to the Supreme Court itself. So, to me, what has been done is proper to see whether they acted in accordance with law. After all, we have the substantive justice and we also have procedural. So if when somebody says I have not been given a hearing, we are not going to the substance. All he wants to establish is that you took a decision against me without necessarily giving me a hearing. That is more procedural, not necessarily a substantive matter. Now, she has continued to say everywhere that she has never been shown what the so-called prima facie determination was all about. Look, if we talk of prima facie, you are saying on the face of it, we find that you have committed some wrongs. Now we set up a committee. What do you think the committee would do? It is for the committee to confirm whether or not what they heard at first blush is correct, or to deny, to say that no, these things were well explained during the hearing, and therefore they no longer form any grounds for which anybody can say that this person ought to be removed. So when the committee is set up, it to act in accordance with law. It should not be on its own. And the woman, the Chief Justice said, show me the prima facie determination that you allegedly made in which areas, so that I prepare to come and give my testimony. They refuse. Give me a copy of the petition. They refuse. The petition which was sent to the Chief Justice was also not given. Right.
But Mr. Iko Otu, please. But the former Chief Justice appeared before the committee to give her side of the story, even though she was not giving a copy of the prima facie case that the Council of State established against her.
What is wrong with that?
I'm just asking for clarity.
But that is what I said. That while she was there, she kept complaining. And they kept doing whatever they wanted to do. So at the end of the process, because they kept saying that it is in camera, all it means is that it is only at the end of the process that you can challenge the things in the court. Do you understand? If she is saying that the grounds, for example, that she might have misappropriated government funds, is not true. Because she is not a spending officer, and that the spending officer, who is the judicial secretary, when the query was raised, explained everything, and the auditors became satisfied. For which reason the auditors did not capture that particular expenditure in their final management report. How then do you turn around to use it against the person that is still involved in having done something wrong? Do you appreciate the point I'm making? It was not a case that somebody has been charged with causing unlawful damage, but this is a case of audit. And in audit, there are steps for doing it. You don't make audit observations and get away with it, but you ask the person being audited to give you an explanation. So once the person gives you an explanation and you are satisfied with it, that ends the matter. And I'm saying that is what happened in this case. The query was raised, the explanation was given, and the final management letter came, and that matter was dropped. How do you turn around to use it? And these were all tendered, and so they were before the committee. Why didn't the committee even comment on those things that went about saying what they are saying? And you think that if somebody is saying that we have sufficient evidence before them, we decided not to look at, and therefore we have come to the High Court. Is there anything wrong with that? Do you appreciate the point I'm making?
Yes.
And then, for example, that she had transferred somebody, and that transfer is a mistake. stated misbehavior. Where? Have you seen such a thing happen before? In your small organization, don't you make changes? I used to be there. It was is it Dr. something who was doing this program? Today I'm called and I find that someone else who is doing the program. We make changes all the time. So if somebody has been transferred, how can this be a ground to remove a whole head of a judiciary because she has transferred somebody? Or that Okwabla went to say she should be removed for having made recommendation to the Supreme Court, and the president and the Senate of State said there was nothing wrong with what the person has done. That amount to res judicata, how did they turn around to use it again against the same person? So you set up a committee to go and do a matter, and then one of the committee members sees it as a strike. That in the morning, right, that the strike is over, the battle is done. Is this person really somebody who is truthful to his oath, that he went there to work in accordance with the evidence before them? So please, to me, allow the Chief Justice to go to court to challenge whatever has happened, and then let's see what the outcome will be. After all, in Riakuto, the Supreme Court refused to say that the fundamental human rights of the detainees had in fact been breached. But today, we are praising Dr. Dankwa for having had the boldness to go to court to challenge it, and rather condemning the judges as tumorous souls. So let us allow the process to go on and see what comes out at the end of the day. If the High Court judge before whom the case goes believes that these are matters that involve interpretation, he has the right to refer it to the Supreme Court.